SJC-13048, Commonwealth v. Christopher Henry.
Okay, Attorney Codignoni.
Morning. May
Did I
it please?
say it right?
Oh, I'm sorry.
Did I say it right?
It's Codignone, Your Honor.
Sorry.
I think that was pretty correct.
Please proceed.
Thank you. May it please the court, Amy Codignone on behalf of Mr. Christopher Henry. This court should vacate the denial of Mr. Henry's motion to withdraw his guilty plea. Turning first to the due process argument, I would ask that this court affirm the plain language of the Commonwealth versus Scott decision and overrule the appeals court's decision limiting due process relief if the defendant can show a charge-specific, I apologize, a drug certificate per charge. I would suggest to the court that the Commonwealth versus Scott decision and the Ferrer decision upon which it relies suggest that the inquiry is one of due process. It's one of whether the defendant can show that his plea is knowing, voluntary, and intelligent. And there are certainly circumstances, as the Massachusetts Appeals Court in the Henry decision considered and recognized, in which a defendant can have a Duke and drug charge within his case that can materially affect his decision to plead guilty.
That's true, counsel, but if I could interrupt you on this one, because one of the things that you allude to in your papers is that the drug charges were really what was driving the plea in this case. But if you look at the way that the case unfolded, it was really the firearms investigation and the firearms prosecution that led to the ancillary charges that came up as a result of the drugs. So you had a case where the firearms and there was the robbery and you had a motion to suppress the identification that was denied. All of that stuff was going to come in at trial. So help me explain help me understand your argument under the first factor, because I just don't, help me understand how you go from the power of the firearms charges to making the argument that what was really driving the bus here were the drugs.
Sure. So I think that those, in my view, are sort of two separate issues. With regard to the first prong, which is what sort of gets him in the door in terms of this due process claim, I think the drug cert alone, and I would argue to this court that the drug cert alone should do that. With regard to I think the court's question, I would suggest that that's more appropriately considered in the reasonable probability prong, because the question of what drove his decision-making to plead guilty is, I think, a little bit different from how the police investigation unfolded. And so you are correct that the police investigation was driven by this purported armed robbery and this I apologize, this gun charge, and that it sort of just happened that he had drugs in his pocket in a school zone when he was arrested. But when he was making the decision of whether or not to plead guilty, and what was driving his decision-making was that he was facing at least 3 years on the drug charges, and he had no defenses to those charges. But he did have defenses to the armed robbery charge and to the firearm charge that went along with the armed robbery charge. And he had strong defenses to those claims. And so when he's considering sort of the totality of the circumstances of his plea, he's considering whether he has defenses to any of the charges. He's looking at already 3 years on the drug charges to which he has no defense. And so he made the decision that he made based upon the information that he had. And that's why I would suggest to the court that having the misconduct in this case is enough to meet the first prong of the Scott analysis, which the plain language of the Scott case says the defendant's case. It doesn't say per charge. And the reason I would suggest that is, and the reason looking back at the Ferrer case that I would suggest that is because the court is looking to what motivated the defendant to plead guilty and what was material to his decision. And so if this court agrees that there is no conclusive presumption in this case, I would agree that sort of inquiry as to what drove his decision-making needs to happen in the first prong. But otherwise, I would suggest, as the lower court did, that it's more appropriately done during the second prong. Did that answer the court's question?
I'm sorry. You did, thank you.
Can I ask you, so the Ferrer case talks about the integrity of the prosecution, and I think you're wise, of course, to break it down into the two parts of the Ferrer prong, and what drives the bus is prong two, right? So let's talk about prong one. If we had a case where a defendant was arrested for murder one, and he just had 2 rocks of crack cocaine found in his pocket, and it was a month-long investigation of murder, and then he pleads guilty to manslaughter, and then in possession of B, based upon these 2 rocks that are found in his pocket. Dukin or Farrak or whoever analyzes the 2 rocks of cocaine. How can the integrity of the prosecution as a whole be impacted by someone who is charged with a throw-in possession crime?
Well, so I would suggest that the integrity of the prosecution is impacted because there's egregious and impermissible misconduct, as the court has recognized that.
Right, and the court has vacated the 2 rocks of cocaine
Right.
as a remedy, right?
And so I would suggest that the issue is whether that defendant should be permitted to withdraw a plea to manslaughter.
Right.
And I think that that's appropriately determined within the second prong. But I would
Well,
suggest that.
well, wait, before we get there, though, I know that's driving the bus language,
Sure.
right? We have to talk about the integrity of that prosecution. Again, how is the integrity of the manslaughter or the murder prosecution impacted by these 2 rocks of cocaine found in someone's pocket?
Well, because you have a chemist who has falsified drug certificates and
Right.
tampered with
All,
evidence.
all
and
real
she-
bad in those counts are vacated.
Sure. Well, but at the time that defendant is pleading guilty, she is proffering evidence within his case, and she would be a testifying witness within his case.
Let me ask you another question, because you rely on the plain language of Scott, and appropriately so, because Scott says case, right? And I think that's the plain language of Scott that you discuss. In Bridgman, which is many years after Scott and is the end of Scott, what we wrote in that case at footnote 26 is that where the defendant, and this is, as you know, in Bridgman, we're talking about all these second letters, and so in Bridgman, we wrote, where the defendant pleads guilty to multiple charges or is convicted of multiple charges, the vacatur of drug charges with prejudice will not affect any non-drug convictions or convictions where Dukin signed the drug certificate. So the Bridgman protocol itself takes non-drug offenses off the table for later remedy. How do you reconcile that with your position today?
Well, so what Mr. Henry is not asking for is that per the Bridgman protocol, that his case just be vacated. That's not what he's asking for. He's asking for the opportunity to show that his due process rights were violated. And the way in which he would do that is by the Scott and Ferrer 2-step process.
But we separated out in Bridgman, drug cases and non-drug cases. And same holds true with Farrak, where we discussed at length drug convictions, never said convictions.
Right.
So at the end of the day, under Farrak and Bridgman, we made a distinction between drug cases and non-drug cases. So again, how is the integrity of the prosecution impacted where we've separated out drug cases from non-drug cases in our remedy?
Well, Your Honor, I would respectfully suggest that there are certain circumstances where a defendant's choice could be dictated by a drug charge, and probably not in Your Honor's example of the manslaughter and 2 rocks of crack cocaine, but there are certainly
But
circumstances.
you would also have so what we're arguing about, and as you appropriately framed it, is whether or not the Scott conclusive presumptions comes in. It would always be open to a defendant to come before a court and to say, my plea was not voluntary because of that. You just wouldn't get the Scott presumption, correct?
Well, no, is my answer to that, because of the way in which the Henry decision and the Lewis decision are written. They cut off the inquiry. If you cannot show a drug certificate bearing Dukin's name to the charge that you are challenging, you have no foot within
I
the
don't
door.
think that's true with respect to Justice Ditkoff's discussion of the case. In Lewis, I think he said it's always open to a defendant to say it wasn't divisible, and you could come in and say, as Justice George's framed it, what was driving the train was the drug case.
So that's not how I read the Lewis decision, Your Honor. The way in which I read the Lewis decision is that Justice Ditkoff indicated that a defendant at the time of the plea would have had to have declared that it was indivisible with the assent of the plea judge. And
Yeah.
quite frankly, that's not the practice that I've seen in the superior courts or the district courts, that a defendant who is pleading guilty to a multi-count indictment would declare with the assent of the plea judge that the plea was indivisible. I would suggest to the court that that if it were that,
What the case is, nor do we foreclose the possibility that a motion judge, especially with a trial judge, who is also the plea judge, might discern from other indicia that the parties intended the guilty pleas to be indivisible, right? So it'd be open to a defendant to convince the judge the reason why I pled guilty was because of drug charges, notwithstanding the fact that I was charged with these firearm offenses that had all sorts of enhancements and got a break on them.
well, in this case, Your Honor, the court, the appeals court below doesn't do that inquiry. What the appeals court did is they look at whether he meets the conclusive presumption charge, or prong rather, determine it's charge specific, which is in contradiction to Scott's plain language. And then they address sort of whether he can meet the prong anyway, but the way in which they address it is by looking specifically at whether or not he can prove that the drug charges here are tainted by Dukin's misconduct, as opposed to whether or not it drove his decision-making. And I would suggest,
And by you say the dictates of Scott, you say that because Scott said the case and
Yes.
not the drug charge.
yes.
Notwithstanding that we said the drug charge in Bridgman, right?
My understanding in Bridgman is that the court was looking to fashion a global remedy for all of these drug charges, and understanding that there were some mixed cases that still existed. The ones that would be dismissed with prejudice, or the ones that would be relitigated, or however they fell on those lists, weren't going to be impacted by the court's sort of sweeping remedy. And that would be up to a defendant to bring a motion to withdraw a guilty plea at some point in the future. And my argument to this court is that the way in which the Henry decision is written and the way in which the Lewis decision is written is that it cuts off the defendant's ability to sort of even enter the door on a due process claim by saying that if you can't produce a drug certificate as to your charges, regardless of whether or not it was material to your decision-making, and regardless as to whether or not it drove your decision to plead guilty, you can't meet the first prong, and so the analysis is done.
I don't know. It seems to me that there's plenty of room in those decisions where you have a situation where somebody pled guilty with Dukin drug certs to trafficking in a large amount within a school zone. And there's a stray assault and battery case where the alleged victim wasn't testifying. He pled guilty on that to a guilty file. There's nobody who's going to say that prong one's not satisfied there, right?
Well, respectfully, Your Honor, I think that that's what these decisions have sort of dictated, because the focus is solely on the drug charges. And with regard to the Lewis decision, I understand that Justice Gaziano and I have sort of differed, but my recollection is that the court stated that it needs to be declared indivisible at the time of the plea. And here, we have a situation where Mr. Henry moved to withdraw his plea in front of a judge that was not the plea judge, because the plea judge had retired. And so that sort of analysis, I think, gets a little bit sticky. And I would ask that this court clarify that it is open to make a due process challenge for a defendant who is asserting that a Dukin drug charge drove his decision to plead guilty. And I think that the Commonwealth versus Claudio decision that came out of this court last year allows for that possibility that a non-drug charge, can be impacted by a Dukin charge. But I think that the Henry decision, which is a published appeals court decision, makes that very difficult for defendants that are trying to litigate these motions at this point.
So you're relying on the sentence that we do not foreclose the possibility that the parties could, at the time of the plea colloquy and with the assent of the plea judge, state that the guilty pleas are indivisible, as that's the only way you get into indivisibility. Is that your reading of what Henry says?
Yes, I think that's the Lewis decision, Your Honor.
Excuse me, the Lewis case. Yeah. Okay. Mm-hmm.
And again, as I stated, I don't think that it's the practice in courts for where you have a case that is multiple indictments within the same case for attorneys to foresee that there might be this type of issue in the future, and to require that type of clairvoyance that in 2011, Mr. Henry's counsel declared the plea indivisible, I think is unfair for him to be held to that requirement.
If we clarify the point that you're disagreeing with Justice Gaziano on, and say that indivisibility is always subject to review, are you content with that, or we still need to go further than that?
So I would be happy with that if indivisibility was subject to review. And I understand that there are certain circumstances where it may have been the intent of the parties to have it divisible or what have you. But I do think that there needs to be some inquiry into the sort of totality of the circumstances as to what the parties intended, without requiring that there have been 10 years ago some declaration by the court and the parties that it was indivisible.
Okay, any further questions? All righty, thanks so much.
Thank you very much.
Attorney Lynn, you have double duty.
Yes, I do. Once again, good morning, Your Honors. May it please the court, Paul Lynn for the Commonwealth. I would first emphasize that this court is reviewing the trial court judge's decision, not the appeals court's decision. So the ultimate question is whether that decision was correct. Lewis is a published case. It states, based on other published cases, that you can divide out pleas. Now, I don't think even the Commonwealth, let me rephrase that. The Commonwealth is not claiming that this should be completely off the table. I don't think that's what Lewis said. I don't think that's what Lewis should say. What it says is that the defendant is not entitled to that first presumption of the Scott standard, that there was egregious misconduct, because the drug charges are gone. The drug charges in this case have been dismissed. They're gone forever. So the Commonwealth's position is that has remedied the Dukan problem in this case. But yes, a defendant can always claim that his plea was involuntary based on information that was withheld from him. And so I think even under Lewis, you look at the second prong of the Scott standard, essentially, or the second prong of the Brady standard, or the second prong of the Grace standard regarding newly discovered evidence. And you look to see, and here's the language from Scott, the defendant must demonstrate a reasonable probability that he would not have pleaded guilty had he known of Dukan's misconduct. In this case, the judge, though he was not the plea judge, did hear evidence, did hear from the defendant himself, and he simply disbelieved the defendant. The defendant admitted on the stand that he was expecting to get 20 years in prison on the robbery and firearm charges. Instead, he got 3 years, 2 of which he had already served.
Let me ask you, Mr. Lynn, on the Scott Ferreira 2 prongs. If the defendant does not show governmental misconduct impacting the case and there's no conclusive presumption, do you even get to prong 2?
I think you do under voluntariness.
That was a problem, Justice. That was just the problem that Justice Spina wrote, given the difficulties of litigating all these Dukan matters. That was the reason why there was a conclusive presumption to bypass prong 1 and get to prong 2. So if you're telling us that you can always get to prong 2, I just question that, because how do you even get there if you don't get to prong 1?
Well, you don't show egregious. You don't have a presumption of egregious government misconduct. So you aren't really operating under Scott, but you can look at it under Miller, or not Miller. I've got Miller on the brain. I'm sorry. Under Brady or Grace as something that was withheld from the defendant. So I think you get to the second prong regardless.
How did Judge Locke in this case analytically get to that second prong when he made the finding that, as Justice George said, what was driving the train?
Well, he applied the Scott standard.
He applied the Scott, yeah. Did he apply the presumption or no?
He did apply the presumption. So then he moved on to the second prong, and under the second prong, he just disbelieved the defendant. And I point out in my brief, not only was the defendant facing this, not only did the defendant testify that he believed he was facing 20 years on the robbery and firearm charges, but when the prosecutor asked him several times, did you really think you would get the maximum sentence for the tiny amount of drugs that you had on you? He wouldn't answer the question. He just said, it's possible, it's possible. So the judge was, I mean, not that a decision of credibility by the trial court
But there
judge.
was a, Mr. Lynn, there was a school zone that was null proster dismissed as part of the overall plea. And I
That
think
is
what the
correct.
defendant would say here is, okay, I know my fingerprints were on the ammunition. I know I got a concurrent with the probation violation. But, you know, I didn't want to go to prison, and I had a serious shot at this motion to suppress, and I wouldn't have pled guilty. It was that I knew I was going for 2 years because of the school zone.
Yes, that's certainly what he said.
And why doesn't that ring true?
Well, it's, first of all, because he testified that he was facing 20 years on the robbery and firearm charges, which is a huge difference. And second, the judge didn't have to believe him. It's not a question of whether it rang true. The question is whether the judge who heard and saw him testify believed it. And he didn't. Also, as the defendant has never argued his motion to suppress in this motion or his appeal. The robbery victim identified him from 2 blind arrays conducted by someone who didn't know who the suspect was. Granted, he was unsure of his identification, but you have this evidence that he identified the defendant from a very fair process. The gun that matched the description of the robber's gun was found in the same room, the same bedroom the defendant came out of, the same room in which the ammunition with his fingerprint was found in.
Let me ask you a question, Mr. Lynn. If you think that we get there under Brady or Grace, and Judge Locke got there under Scott, and to the ultimate question about was it, you know, what drove the train? And I understand your arguments and the deference we owe to Judge Locke, who heard the witnesses. How's the government harmed if we just go to prong 2? What's your stake in this? Why do you care?
If you go to prong 2?
Yeah, if we just go to prong 2, if we agree with your sister and say, we'll apply the Scott, we'll use the broad Scott language, we'll apply the presumption in Scott and go to prong 2 in every case, what difference does it make to you?
I would object to this court explicitly overruling Lewis, that the court has to apply the Scott analysis. But yes, I think you do go to the second prong even under Lewis.
But you just told me we get to prong 2 under Brady and Grace, and Locke got to prong 2 and the right result happened. So why do we care?
I suppose we don't care. The decision, regardless, is affirmation of the trial court judge's, Judge Locke's decision.
What about my manslaughter hypothetical? Would you care then?
Well, I think under those circumstances, it's the same situation, really. It's just in that case, you have a situation in which it is clear beyond any doubt whatsoever that the defendant would not have changed his plea based on the drug charges. And again, the only question regarding, excuse me,
Mr. Lynn, I'm getting confused now. So Judge Locke, in your view, Judge Locke should not have, how would he get to, how does his analysis, should his analysis have proceeded if we don't, if Henry and Lewis are right and there isn't a prong 1, what is the second part of his analysis and how does it work? Well, I mean, so I read Henry and Lewis as saying, okay, if you don't meet prong 1, we don't go to prong 2, except for there's this indivisibility issue. Does he have to do a totally different analysis, or is it the exact same analysis as prong 2 under the indivisibility analysis?
I think I'd better go back a step. I think the important thing to realize is that long before the Dukan Farrick scandals broke, defendants were challenging their pleas on the grounds that they were involuntary.
Right, I get it.
So there was always the question of whether there was some error that took place
Right.
that caused their plea to be involuntary. So I think we're hung up on discussing the second prong of Scott, as opposed to just looking globally at whether or not this error, regardless of whether it was egregious governmental misconduct, made the defendant's plea involuntary. And
We have-
yeah,
We
go
have
ahead.
to provide some guidance here, right? Because there's some confusion about what a trial judge, I mean, we've got a very good trial judge here. We got some confusion about if Henry and Lewis are correct, that we don't have a prong one finding, does that mean we move to a totally different, the old form of analysis, and we don't move to prong two of this? We go back to the some different old test? Is that what we're supposed to do? I just want to know what we tell trial judges if we agree that Henry and Lewis are correct on this prong one analysis.
That's the Commonwealth's primary argument is yes, you tell the trial court judges to engage in the same analysis regarding the intelligence and voluntariness of a plea that they've been engaging in since time immemorial. In the alternative.
And how is that different from what's happened under prong two of?
Not much. Yes, that's what this court has said in Scott is when you look at the pre-Dukan standards of review for, if you look at it under withholding under Brady, if you look at it as new evidence under Grace, the standard for materiality under those tests is essentially the second prong of the Scott analysis. And that's really what the courts have always looked at. Was the problem material to the defendant's decision? And here, Judge Locke found, as a matter of fact and credibility, that it was not.
You know, Mr. Lynn, I just don't know if that's how it works in the real world. If you're sitting there looking at prong two of Scott, as opposed to some other situation where you're determining whether the plea actually was knowingly and voluntarily made, if you're the defendant, you'd rather have gotten there through Scott and get to prong two of Scott than otherwise, it seems. And maybe that intangible isn't supported by doctrine, and you're completely right.
I really can't answer that question more than I have, and I am have less experience in the trial court than you do.
But so, Mr. Lynn, if we adopt your view, Judge Locke, we don't need to remand this to Judge Locke because he had basically applied the same test through prong two that he would have applied under the old standard. Is that your
That's
view?
exactly right. Yes, that was the right decision. However, he came to it, or whatever the law regarding this issue is.
Okay.
The bottom line is he disbelieved the defendant.
I got it.
Okay, do we have any further questions?
Well, thank you, Chief.
Okay, thanks so much.
Thank
And we'll
you.
take our morning break.